I think one of the most important things you can remember about permanency hearings is the necessity to look to progress versus compliance. For years, hoops were set up and we judged cases and parents by how many hoops they jumped through. And unfortunately, there were times when more hoops got added to the end of the list. We're really trying to change the way that's done, and we're trying to look at the progress that folks are making towards the ultimate goal. So for example, we're asking the agency to give us articulable goals. So for example, go to AA. Well, the goal behind going to AA is to maintain a sober lifestyle. So if a parent can come in and prove to us that they're maintaining a sober lifestyle, does the fact that they actually went to the AA meeting matter as much? And it may not, depending on a particular case. But some may say the progress is more important than the actual compliance. So what we're finding is that a lot of caseworkers are drafting much more specific case plans to actually achieve the goals that we're seeking, which is, for example, not go to AA, but instead maintain a sober lifestyle. When you get to your permanency hearings, you really need to examine what the goal is, because the goal being go to parenting classes doesn't help us as much as this parent really needs to be educated about the developmental differences of her two children that might be 5 years apart in age. So her going to a parenting class that focuses on teenagers, while it would have satisfied her obligation to attend a parenting class, doesn't really achieve the goal, which is to educate her about what she needs to know to better be able to provide for her children. So progress versus compliance is one of the key takeaways in a permanency hearing. Another thing to look to at a permanency hearing is the court's going to be asking you whether the current placement needs to be continued. Is it time for this child to go home? If it's not time for this child to go home, have we exhausted all other efforts? Again, I encourage you to go out and find the people that can make your case. At this point, the case has been ongoing for at least 6 months. I'm certain your child has come up with an opinion or two. Hopefully you've engaged with your client, you've met with your client, you know what they would like to see happen. And this is the time to make the case for that child to get what they want, assuming that can happen in a safe manner. So if the child wishes to return home, this is the time to make that case. If there are still nagging safety issues, have you proactively tried to address them? If a parent, for example, was asked to take anger management courses and they hadn't complied and completed them by the time of the permanency hearing, you need to ask the court if strict compliance is what our goal is, or is trying to get a child returned to their family who are trying and making progress in the plan. The effort to find family should never stop. We can never say we've looked everywhere and we've exhausted those efforts, so I encourage you to ask the question again at the permanency hearing. Hopefully you've done some of that investigation on your own and maybe you've identified some folks or the caseworker has brought new people before the court, but it's your role to reach out to them and call and ask if they're willing to be a resource for this child. It doesn't necessarily mean placement with them, but the more people that these children have that care about them and love them, the better off they're going to be in the long run. So again, permanency hearings are really about, there's status checks. Should we continue going down the course we're going, or do we change? And I encourage you to be able to answer that question before you even get there, because as you ask yourself that question, you're going to find gaps and you're going to see that you need more information, and hopefully you'll reach out, get that information, and be able to make the best case that you can at the permanency review.
Make sure that you're familiar with all the rules. There are a lot of needs that kids have. I want you to, one of the things to find out what those needs are. A number of times as lawyers, we get caught up in what we know as a lawyer. So look out and reach out to others for additional training, some other more experienced GALs. I'll talk to them as well so that you can understand the needs of your client based on their ages. Obviously, if you have a young child that's 2 or 3 versus one that's 14, 15, their needs and the things that they see are different. So expand your knowledge in regard to those areas as well. Maximize the child's participation in the decision-making process. Even on those occasions where you don't agree with the child, you still need to hear it, explain your thoughts and your view of the case, but they need to be involved so they can understand it. And normally what happens, if they understand exactly where you're coming from, it's easier to represent them in court, as well as easier for them to follow the recommendations of the judges as well. Make sure that you see your child in their context. They all have families, communities, different cultures that that are there and involved with. So you want to see their worldview. A lot of times we get caught up in the adversarial role. Many times, that's ineffective and inefficient as well in regard to meeting your client's needs. So make sure that you collaborate with others in the courtroom as well. Don't be satisfied with the first impression of the child. Many times you have a child that you ask them a question, he gives you a one-word answer, or they're shy, they don't want to talk to you. Many times what they need is someone that they trust, someone that's going to be on their side. So take the time to get to know your client.